you may wonder why we focused a meeting on employment law. Well, partly because of the work we've done with international recruitment, partly the work we're actually doing with recruitment, and partly from the calls we get from providers. There's been a lot of changes to employment law, or they're planned for this year. And we're delighted that Citation have been able to ask Dominic Cooper to come and join us this morning. What we do find is that we find that quite a lot of employment laws are frequently ignored in social care. And you will also notice that there is a heightened visitation across social care from organisations such as HMRC. We've already had a brief conversation about CQC inspections, and also, of course, there are the local authority quality monitoring. And where international recruits are involved, you will also find the gangmasters coming in, GLAA, and the Home Office UKVI inspection teams. So you need to get your paperwork, you need to be able to evidence that you are doing the job properly. And we've had a case in the past few days of a company that has decided to let people go, and those people have apparently got no contract, no job description, etc., all of which is not right. And before I lose my voice, I will pass over to Dominic Cooper from Citation, who will introduce himself, and then he will give you a lot of information. And if you've got questions, please keep them for the end, put them in the chat, or if you aren't quite sure, pass them on to us, to Dudley and myself afterwards, and we will make sure that they get to Dominic for answers. Thank you.
Okay, right. Thanks, Peter. Yeah, I do have the slides. Are you going to share them, or
I can share them? Yeah, I can share them. If you let me just find them on there.
Okay. Yes, that looks the one. Okay. Actually, do I need to ask you when to move on to the next slide?
Probably yes.
Yeah. Okay, no problem. All right. Well, yes, I will crack on because, as Peter says, I've got a lot of information to get to. Happy to answer questions. But yeah, if we can try and answer them at the end, that might work a bit better. But yeah, there's a lot to get to because, as Peter alluded to, this is that a very busy year for changes in employment law, and I'd agree that it is important to get it right. But before I get fully into that, a bit of an introduction. Yeah, my name is Dominic Cooper. I am a solicitor, officially professional support solicitor at Citation. And yes, Citation. Yes, so you just want to move on, Peter. Next slide. Yeah, we're a very large provider. I think possibly the largest now of HR and employment law services and health and safety services, as well as various other services we do across the group. Grown a lot in the 10 years I've been here and continue to do so. Don't know if any of you are current clients. But yeah, if not, please feel free to talk to my colleague, Mick. Yeah, just next slide, please. So just some introductory slides here, but yeah, next one, as I say, we've got various companies within our group. These are just a few of them. We offer various complementary services such as DBS and right to work checks, online training, cybersecurity, ISO accreditation, and we do have a whole load of products just for the care sector as well, like mock inspections and specialist policies, CQC Pro, that kind of thing. As I say, I'm sure Mick can tell you all about that later on. Right, just next slide, please. Yeah, so today's presentation, as it says here, it's an overview of recent and upcoming changes in employment law, just to make you aware and so you can start planning accordingly. We've actually seen more changes this year than we have for a long time. Maybe slight elephant in the room, there's going to be even more changes if and when, increasingly looks like when Labour government comes in, they've got some big changes planned, but they're still hypothetical at the moment. But there's a lot of actual changes have been made. There's no radical overhauls at the moment, but there's a lot of adjustments to existing legislation. There's the introduction of some new rights. I think some of these will have a bigger effect on you than others, but most of them are relevant to all employers to a greater or lesser extent, so they are definitely worth knowing about. And you will note it says here this relates to GB only, in that with the exception of the Carers Leave Act, all of this and all the legislation I'm discussing applies to England, Wales, and Scotland, but not Northern Ireland. But I'm guessing none of you, operate in Northern Ireland, or if you do, it might just be kind of as a bit of a branch office or something, but just worth knowing that it's just in GB. Okay, so you just move on. Yeah. Okay, so I've actually missed out the title of the relevant legislation here, but the Employment Rights Amendment, Revocation and Transitional Provisions Regulations 2023 is what we're going to talk about first. It's probably the most significant changes. It's a bit of an opaque title, but it's, like I said, it's quite significant, particularly in relation to holidays. And most important change is that creates a new process for calculating the accrual and payments of holidays for some workers, which we'll go on to in more detail in the next few slides. But there's also various points derived from case law, particularly EU case law, that's now collating into one place, and it's confirming will remain law in the UK post-Brexit. So again, I'll cover those a bit later. But before I go on to the holiday provisions, and I know TUPE transfers are maybe less common within the care sector than some other industries. But if you don't know what TUPE is, transfer of undertakings, protection of employment regulations, applies when you take over a business or part of a business and the staff come with it. But yeah, there's been some changes on that. These regulations are going to give some more flexibility on consultation, so you can go straight to consulting directly with individuals rather than appointing representatives. If either the business has less than 50 employees or there are fewer than 10 employees transferring over with the work. Previously, that option of individual consultation was only open to micro businesses with less than 10 employees. So that's, quite, a bit of a change there. Okay, just next slide, please, Peter. Oh, sorry, I won't, I'm getting ahead of myself. It's still on that same slide. But yeah, the first key point to note is that changes to holiday accrual and pay, they're not universal. They only apply to those on irregular hours and part-year workers. So for the purpose of the regulations, an irregular worker is someone whose hours usually differ in each pay period. So from week to week, month to month, depending on what interval they're paid at. Part-year worker is someone who has more regular hours when they are working, but they're not required to work or be available all year round. They have at least 1 week every year in which they don't work and they're not paid for it. So term time workers, classic example, seasonal workers. I'm not sure how many people you have who fit in that category, but it might be more commonly you have the irregular hours worker on 0 hours or something like that. So the regulations are already in force, but the holiday provisions only apply to holiday years starting from 1st of April. So it is now kicking in for, more recently, but if you have a January to December holiday year, which is possibly the most common arrangement, these new rules will only be only available from next year. So there's plenty of time to prepare. Okay, so the usual rules under the working time regulations, all workers are entitled to 5.6 weeks holiday. When you calculate what counts as a week's pay for these purposes, you take a 52-week average and you disregard any weeks when they're not working, they're not remunerated. For those on variable or unusual working patterns, calculation had often been taken that the holiday entitlement equated to 12.07% of the time worked in a year. But the Brazell case, Brazell and Harper Trust, a few years ago, maybe 7 years ago now, that stated that shouldn't be used. Only the 5.6 weeks figure was allowed by the regulations, and you need to take a 52-week average to work out what a week equated to. So that caused a lot of disruption, particularly in the education sector with term time workers. And also there had often been the use of rolled up holiday pay, which is paying a lump sum each week or each month rather than paying for the holiday as it was taken. That was not allowed because it creates an incentive not to take holiday, which is a breach of the health and safety purposes of the working time regulations. So for a long time, that was prohibited, but these new rules now allow that in certain circumstances. Yeah, so next slide, please. Yeah, so holidays are usually paid at the point in which they're taken, but in legal terms, they are strictly speaking separate rights. And so under the new regulations, you can use rolled up holiday pay, which does disconnect the holiday from the payment. So, you're not getting paid for the holiday at the point at which you take it. As I say, it's a lump sum paid on top of the wages, needs to be itemized separately on the pay slip. Sorry. Okay, sorry. Right, so you calculate the rolled up holiday pay in each pay period, 12.07% of the hours worked in that period, and you pay it regardless of how much holiday the employee has taken in that pay period of month or week. Now, you might be thinking that's a bit of an odd figure, 12.07%, but it's based on a ratio of 5.6 weeks holiday to 46.4 working weeks in normal arrangements. So if your standard holiday entitlement for full-time fixed hours workers is more generous, the percentage is going to be a little bit higher than that. Okay, so yeah, I'll maybe come back to that, Harriet, at the end if you just remind me. Yeah, so periods that spent on holiday, the worker's obviously not working, so that wouldn't count towards the calculation for that week or that month, but it would. The rolled up holiday pay would still be paid while they're off sick, on family leave. That's based on a 52-week average. However, it's important to remember that the employee, the worker, is still entitled to take the holiday. And the risk with rolled up holiday pay is that it incentivizes them not to take their holiday and to exhaust themselves, not take sufficient rest, because they're not going to be paid for that time. So they might say, well, I'm not going to take it. I'll just get a sort of yeah, Adrian, I can just quickly answer that. Yeah, so that was the rule Brazil said you couldn't pay 12.07%, but the point of these regulations is effectively to reverse that. The government said we don't like that ruling, so we're going to kind of override it with new legislation. Yeah, so it's important that you do comply with your health and safety obligations by encouraging people to take their holiday rather than just keep taking the uplift. Okay, just go to the next slide. Yeah, so in the same way that you're able to calculate holiday as 12.07% of the hours, you're now able to treat the accrual of the holiday itself, i.e. the time to be taken off rather than paid, as accruing at the same rate. So again, if the worker's off sick or on family leave, it's based on the 52-week average. So that will result quite often in odd fractions and minutes where someone's accrued, say, 4 hours and 17 minutes or something strange. So in that case, you'd round it up or down to the nearest half hour. If it's less than half an hour, you round it down. If it's more than half an hour, you round it up. And if an individual has weeks where they don't work, such as a 0 hours worker, they can end up accruing and taking less than 5.6 weeks holiday in a year. So that's a real deviation from the usual rules, the previous legal position. So, but nevertheless, these regulations are confirming that is a valid option now. And it's an option. This isn't something that you have to do for people on 0 hours or irregular patterns. It's just saying that this is the kind of bare minimum. You can keep paying them at 5.6 weeks, or indeed more than that. Yeah, next slide, please. So the regulations are not all change in the sense that they do put into legislation some points that were previously just based on case law, particularly from EU law. And the first point to note is that the EU Working Time Directive created a right to four weeks holiday, which is paid on the basis of normal pay, which includes commission, bonuses, guaranteed overtime, anything that's inherently connected to, intrinsically linked to the performance of your role. And then the working time regulations, which is the UK legislation, that gave an additional 1.6 weeks, which is 8 days for full-time staff, and that is paid a basic pay, so not including commission bonuses and so on. So it can be quite confusing if you're sticking strictly to that. And so we thought that might be kind of rationalised and changed in these regulations, but in their wisdom, the government decided not to. They've kept that distinction. Yeah, so move on to the next slide, please. So usually your holiday can't be carried over to the following year, but there are 3 scenarios in which it can be, and the regulations, this is what came from the case law particularly, and this is what the regulations have been forcing. So the employee is on statutory leave, such as maternity leave, and therefore they're unable to take the holiday. They can potentially roll over up to the full 5.6 weeks, their full entitlement. If they're unable to take the holiday because they're off sick, like long-term sick, they can carry over up to 4 weeks. So essentially the European entitlement as was. But that needs to be taken within 18 hours. The employee can potentially carry over up to 4 weeks if the employer refuses to allow them to take their leave or be paid their leave, or even in some cases if the employer just fails to adequately warn them that it's going to be lost if they don't take it. So we'd always encourage you to, towards the end of the holiday year, be checking how much holiday the people have left and reminding them you do need to take this, otherwise you're going to lose it. Okay, next slide. Yeah, so just really, quite a lot of changes to holiday rules there. So we recommend just reviewing what your current wording in the contract and handbooks and so on are. Thinking, do we want to change this? Do we want to introduce changes, or possibly if you want to, if you hadn't been paying commission, for instance, do we want to, well, maybe not so much commission in the care sector, but guaranteed overtime, something like that. Do we want to rectify that? We need to kind of update our current practices. And yeah, do we want to introduce this 12% accrual? If so, we're going to need a consultation process, probably a collective consultation process, which is a lot more formal if you've got more than 20 people affected. But also bear in mind, as I said, the health and safety implications of people, not being paid for their holiday and potentially therefore not taking it. And also, if you are going to change to this different system, how are you going to keep track of what's being accrued and what's taken at any given point? Okay, yeah, so next slide. Yeah, so moving on to new changes, few changes to the flexible working provisions. One of a few changes that took effect last month. So these regulations themselves only made the one change, but it's a significant one in that the right to request flexible working is now a day one right. You don't require 6 months service or 26 weeks service as you previously did. So in theory, someone could, apply for a 4-day-a-week role, and then within their first week say, actually, I want to drop down to 2 weeks. 2 days. You certainly don't necessarily need to agree to that, but they've got the right to request it and for it to be given proper consideration. Yeah, so next slide. So slightly confusingly, there was 2 different pieces of legislation. So last one was the regulations. This is the Act. This has now also come into force in the last few weeks. We were expecting it to come into force later in the year, but it got rushed through. Came through on 6th of April in the end. So first point to note is an employee can now make 2 requests for flexible working rather than 1 in a 12-month period. The employer's time frame for confirming their decision and dealing with any appeal, that's been reduced from 3 months to 2 months. There's also more of an obligation now on the employer to proactively consult and explore alternative options. There's no obligation anymore for the employee to suggest how the impact of their request can be mitigated. It's much more on justifying the employer justifying why it can't be accommodated rather than the employee having to convince you that it can be. And what isn't changing though is the list of business reasons that you can rely on to refuse the request, which are actually quite broad, will apply to many, if not most situations. So things like increased costs, inability to cover the work by existing staff, inability to recruit replacements, detrimental impact on quality, detrimental impact on performance. They're all still in place. Okay, next slide. Yeah, so carers leave. This is an entirely new right that's just come into force in April. This applies to the whole of the UK, albeit it hasn't technically been implemented in Northern Ireland yet. It creates a new right to take up to 1 week of leave in each rolling 12-month period. It's an unpaid period to provide care for a dependent with a long-term care need. Definition of a dependent, mostly common sense, a spouse, a child, parent, also someone living in the same household, but not as a tenant or lodger or something more transactional. But also it can be someone who relies on the employee for care, such as, if they've got an elderly neighbour and they go and, collect their medication or do their shopping for them, or take them to appointments, they can do that. Or, their best friend needs support when they're ill, that can also apply. A long-term care need is an illness or injury. Illness or injury that's likely to require care for more than 3 months. It's a disability as defined in the Equality Act, or its needs connected to old age. So the leave can be taken as single days or half days. Does need to be requested in advance, so it's different from the existing right of emergency time off for dependents in that sense. The notice is either 3 days or twice the length of the absence. So if they want to take 1 day, they need to give you 3 days notice. But if they want, a 5-day week off, they need to give 10 days notice. You can postpone the taking of the leave if there's reasonable grounds for doing so, but you can only postpone it up to a month, and you can't refuse it altogether. The regulations do state that you can't require the employee to provide evidence of why the leave is needed either. So you do need to take it on in good faith to an extent. Next slide, please. Yeah, so really just preparing for that new right. What do we need to do? Just make employees aware that they now have this right. Train the managers on their obligations about, what's allowed, what's not allowed, how they need to approach this. Do consider whether you want to create a whole new policy or update your existing policies. If you are citation clients, we already have kind of standard wording for a policy on that subject. And also just update your absence recording systems so you've got a separate category for carers leave if applicable. Okay, next slide, please. Okay, so hopefully you're already aware that a woman has a right to return to the same role after maternity leave, and that if their role becomes redundant while they're on maternity leave, they are entitled to be given any suitable alternative vacancy if they want it. They don't need to go through a selection process with everyone else, don't need to be interviewed. But up to now, that had only applied during the maternity leave. It's now been extended, like this act has now extended those protections to cover the whole period from when the employer becomes aware of the pregnancy to 18 months after the birth. So quite a long period. And that's largely mirrored in adoption situations, and that will be 18 months from the placement date, but not the period before the placement. It also applies to an employee who's taken 6 continuous weeks of shared parental leave. So they're protected until 18 months after the birth as well, which is perhaps a surprisingly generous protection. But nevertheless, that is what the Act says. And of course, it still remains the case that dismissal, whether redundancy or otherwise, will be automatically unfair if it is directly because of pregnancy or maternity leave itself. and that's not time limited. That's always going to apply. Yeah, next slide. Yes, so paternity leave regulations, they came into force on 8th of March, but in relation to babies due from the 6th of April, they make the paternity leave more flexible now, including being able to split your 2-week entitlement into separate weeks, two separate weeks, and you can also take the leave at any point in the first year after the birth rather than within 8 weeks. There's also a slight change to the notification rules, that the employee, it's kind of a 2-stage process now, that the employee informs you of their intention to take paternity leave at 15 weeks before the due date, but they only have to inform you of the specific dates of the leave 28 days before they are taking it. Previously you had to do both of those things at the same point at the 15-week stage. Okay, so next slide. Yeah, the next couple are really just a roundup of other, maybe less significant changes that are coming up. 1st of July 24, I've already mentioned the 2P change. Employment Allocation Tips Act, again coming in July, but I'm sure that's not really applicable in your sector. Worker Protection Act coming in October, that introduces a duty to actively take reasonable steps to prevent sexual harassment. And if you found not to have done enough to reduce a foreseeable risk of harassment, it can result in quite a significant uplift on the tribunal award, up to 25%. But in a way, not too much is changing on that, because the relevant steps you should be taking are the sorts of things that we would already recommend as good practice about, having a robust policy, making sure everyone is trained on it. If you are sort of spotting the warning signs, nipping it in the bud at an informal stage and reminding people to, treat their colleagues with respect, regular refreshers on training, that kind of thing. It's just, that's what the Act is trying to encourage you to do. But now it's saying that, it can actually increase the punishment rather than it just making it more likely that you're going to lose that claim.
I'm sorry, Peter. I'm sorry, Dominic. Peter, can you just move your slide a bit, because it's in the way and some people want to read it. So I'm not sure if you can just, the cursor may move. Just
the little menu is hanging over. Right. So Workers' Predictable Terms and Conditions Act. So this act will give a right to request, but not necessarily be given, more predictable working pattern. Where the working pattern currently lacks certainty in terms of the hours or the times they work, or if it's a fixed term contract for less than 12 months, they can effectively ask to be made permanent. Mostly applies to 0 hours workers, really. Almost sort of, you will be able to refuse that on various valid business reasons. We don't know exactly, imagine that they're going to be similar to the reasons you can use in relation to flexible working. And there will be a code of practice on that subject coming out too, and Citation will put out guidance. Last one on that slide. Neonatal care Act introduces a right to take up to 12 weeks leave if your child who is 28 days old or younger, that's a neonate, is admitted to the hospital for 7 days or more. That leave is not dependent on service, but the right to pay for it is dependent on length of service and earnings in the same way that statutory maternity pay is. That's likely to come into force around this time next year. Next slide, please. Just a couple more on this. The Fire and Rehire Code of Practice. So there's going to be a new code of practice on this slightly controversial topic, also known as dismissal and re-engagement. So that's going to place a higher obligation. It's not saying that you won't be able to dismiss and re-engage people to kind of force through changes to terms, but it's going to place a much higher obligation to provide information, engage in meaningful consultation, genuinely explore all the alternatives, and make sure the fire and rehire is truly a last resort. That there really is, that you've exhausted all other options. Will also discourage the use of threats of dismissal to create pressure on employees. There isn't currently a specific date when that's going to be published, but it's going to be certainly within the next 6 months, I would think. Late summer into autumn. And yeah, non-compete clause. I'm not sure how widely you would use non-compete clauses in your contracts, but the governments have announced, just for completeness, that they will be limiting the duration of those to a maximum of 3 months. Okay, just go to the next slide. So I think Peter alluded at the start that, as well as employment law, there's a lot of inspection by external bodies such as HMRC. So I was asked to give a quick overview of minimum wage. So this is not kind of an update or anything particularly changing. This is just really quick recap. Yeah, so we go to the next slide. Got the information. So as usual, the standard rate of the minimum wage, aka the living wage, has gone up last month to £11.44. It's slightly higher than usual rate of increase. However, there was a bit of a change this year in that previously there was a separate rate for adults who were 21 to 22 years old. And then the main rate applied from 23. That's now been scrapped. So the standard rate now starts from age 21 rather than 23. It's worth remembering with the minimum wage that the law doesn't say that every single worked hour has to be paid at the minimum rate. It's just that the average taken over a 17-week period. That's working time. Sorry, taken over the pay period, whatever's applicable, that exceeds the minimum wage rate. So all wages paid in that period divided by all the hours worked in that period need to average out at more than £11.44. So one point to note that's often missed is that any time spent attending training at the workplace or training in normal working hours, that still counts as working time. And furthermore, for anyone who's paid by the hour, any time where the employee has to be present at or near the workplace or traveling for work purposes, that's working time as well. That needs to be included in the calculation because they're deemed to be under the employee's control. That time is not their own. Even though they're not kind of working as such, they are still, doing something connected to their work. So it's counted as working time. Yeah, next slide, please. Right, so one of the main areas where businesses can get caught out is where the headline rate of pay is fine. Like in the contract, it says you're paid £12 an hour. That's absolutely fine. But then there are agreed deductions or there's compulsory payments by the worker for certain purposes, and they're deemed to reduce the wages and they'll put you in breach. So, any deductions that constitute expenditure connected to the employee's employment or deductions made by the employer for its own use or benefit, they'll be deemed to reduce the pay for minimum wage purposes. So in that latter case, that'll still be a breach even if it benefits the employee too. So, in the nursery sector, the classic one is if you're making a deduction straight from the wages because the employees got their own child in the nursery, and so you're taking the fees directly from their wages. In your sector, it might be if they have a relative in the care home, you're saying rather than us pay you the wages, then you pay us the fees for care of your mother or father. We'll just deduct it straight from your wages. That is reducing their minimum wage, so that can be a problem. But it can also, it's worth noting the same rules apply to payments that employees required to make in connection with their employment, or for which, or that are for the employee's use or benefit. So that could include petrol and travel costs if they're visiting numerous customers during the day. If the employer doesn't reimburse them, that's a loss to the employee, and they've incurred that cost purely because of their work. quite a common pitfall is requiring an employee to buy their own uniform or very specific work clothes. Doesn't have to be a branded uniform as such. Yeah, if you require them to buy a very specific item of clothing just for work purposes, that could still qualify. You know, given the example of, you know, a red top there. But, you know, what would be permitted is the employee spending their own money on that item of clothing, and then the employer agrees to reimburse them afterwards. However, you know, some deductions won't be deemed to reduce wages. The most obvious one is tax, national insurance, but also, you know, the repayment of any loans, advance of wages, or any accidental overpayments of wages, payments to third parties that aren't for the employee's benefit, such as trade union subs or pension contributions is an obvious one, and also deductions in respect of the conduct of the worker or amounts that they're contractually liable for, as long as the deductions are authorised in advance by the contract or another agreement. So, you know, if they've got, you know, if you provide them a car and you're saying that you know, if you have an accident, you know, the first £100 worth of damage will be deducted from your wages. If they've agreed to that in advance, that's fine. That doesn't reduce the wages for minimum wage purposes. Okay, next slide, and this is the last kind of substantive slide if you're feeling a bit befuddled. This is a bit more sort of care specific. These are just sort of pitfalls that we've seen in the care sector. So one area that can often catch out employers in the domiciliary care sector is that all time spent traveling between appointments is considered working time, as I mentioned, and that needs to be included in the calculation of the total hours. The first and last journey of the day to and from home, what you might call the commute, are not included for those purposes. But, you know, once they've started working, traveling between appointments is working time. Similarly, any what you might call, you know, dead time between appointments, you know, if it's not a nominated break, but the employee can't realistically use that for their own purposes, that's still working time. It is okay to pay a low rate for travel time if the contact time is at a higher rate and the combined average, the combined total averages out above the minimum wage. Another area that was very problematic a few years ago was the status of sleeping shifts. I imagine some of you may well remember, you know, a lot of the problems that were caused then, but the default position in the regs is that all time when a worker is required to be available at or near a place of work for the purposes of working, that should be included in the minimum wage calculation. So on the face of it, that would make, or certainly would often make, an overnight sleeping shift uneconomic, you know, completely unaffordable of having to pay every single hour at £11.44. However, there is an exception whereby the worker will only be deemed to be available for work for whatever time they are awake for the purpose of working. So if you're making a lump sum payment of, say, £40, £50 for the whole period, that should be enough to cover you if you've only woken up 2 or 3 times during the night for, say, 10 or 15 minutes at a time. You know, that's going to average out absolutely fine. And the final point that came up in the recent talk I did with other care employers was regarding the accommodation offset, which is an option in the regulations, so that you are allowed to deduct up to £9.99 per day, or something like £68 per week, whatever it equates to, if you provide accommodation as part of the work. So the question that was asked was whether that could apply to living care arrangements, saying, like, you know, if the worker is living at the service user's home for a week, that's accommodation. Can we, you know, make a deduction in relation to that? And the answer is unfortunately not. That's not considered a benefit in kind that the employer is providing. The HMRC guidance confirms that the accommodation provided by a third party is not eligible for these purposes. It needs to be directly provided by the employer for the purposes of working, or as a kind of perk. Okay, yeah, so that's go on to the next slide. You know, that is all I've got to cover today. I know I've rattled through an awful lot there very quickly, and I could see some questions coming in, so I hope you've managed to retain at least some of the information. But yeah, did anyone have any particular questions that you wanted to cover?
I mean, there were some questions in the chat. I'm not sure if
Yeah.
you can go through them as well, Dominic, and see if ones that you may be able to sort of answer as well. And if anyone wants to raise their hands, if they have a specific question, we haven't got long, so probably best to try and grab him whilst you can. So please, anyone wants to raise a hand, they can do. There's a question they want to ask.
Okay. Well, let me just start. I can see there's one from Harriet. So I think this is in relation to what counts as an irregular or part-year worker. So you've got living carers who work for 3 weeks on 1 week. Yeah, 3 weeks on, 1 week off. So do you not count the week they are off? I can't remember exactly what point that came up, but I think in terms of like meeting the definition to be eligible for the accrual, well, yes, if they've got weeks where they're not working and they're not paid for those weeks, then yeah, they come within the definition of part-year worker. But then I think if you're asking about when you're sort of taking an average of hours worked in a pay period, yeah, you would disregard the weeks in which they're not working, because that would otherwise drag down the average. Let's see. Were there other questions? By 1.6 additional UK holidays from someone at Prime Home Care. If someone decides to work during the days, will we still owe them holiday for these days? So, yeah, I mean, if someone is working through a holiday, they haven't had that holiday, so they are still owed it. But I think it would be an unusual one where you sort of dictated you must take these days off as holiday, and then someone is insisting on working through it. I think you would be within your rights to say, no, we're sending you home. You're not working. But yeah, if it's, say, bank holidays, obviously if it's nominally a bank holiday, but someone works during it, they haven't had the benefits of the bank holiday. So you need to give them that day in lieu of some other time. But like I say, normally you would be agreeing when is holiday and when you're working. Let's see, any other questions? Can you shed more light on the flexi working for carers on the regular hours contract? I think it was, I can't remember exact context that was asked for, but I think it was this possible. I don't know whether this was really about the flexible working or the right to request more predictable terms. Whoever sort of asked that question, could you maybe kind of just explain to me what you're getting at?
Yeah, that was me. It's more of in terms of the carers, as you know, because of the rota. I got to ask a question when we updated our policies. Was that okay? So can I choose to decide when I work and where I work? And I was like, okay, I don't think it works that way, but I'm attending this meeting, so I'll clarify that in terms of how many times can they do this and what is within their rights for such requests.
Okay, yeah. So they want to change their working pattern, saying, yeah, maybe we don't want fixed hours, but they want to be more flexible, or they're working Monday to Wednesday and they want to change to Thursday to Friday. They have a statutory right to request that, and you then need to arrange a meeting to discuss that, say what were the reasons why you want to do that. They don't have to justify it quite so much now as they used to, but it's always worth getting a bit of context. You can talk about, well, not prejudge the outcome, but these are the potential issues it could cause for the business. And have you maybe considered any other alternatives? And just really sort of talk through all the options and the reasons behind it. Then you have to go away and look at, well, can we accommodate that? What effect is that going to have? Is that going to cause a gap in the rota? How much of a big problem is that gap in the rota going to be? Can I cover that with other people? Can I recruit new people? But if you can demonstrate that there's a clear case that we can't afford to recruit someone new, or it's going to be too difficult to recruit someone to work only only half a day a week or something, or the rota is so tight that we can't move people around, then you can go back to the employee and say, unfortunately, it's not going to work out. You can put forward an alternative, say this could work out if you're willing to agree to it. But equally, if you've got a valid statutory reason, you can just refuse it. They do still then have a right of appeal, and you do still then obviously need to take that seriously and respond to that in a timely manner. But yeah, that's the kind of general gist of it.
It's
That you need to be seen to
Yeah.
kind of be seen to give it good consideration and not reject it out of hand and say, oh, well, that's not going to work. But if you can show a good business case why it's not going to work, then that's fine.
Okay. All right. Thank you so much. That answers my question.
Okay.
Hi.
And
Hi there.
yes.
Sorry, this is Salma from Prime Home Care.
Hi.
Just going back to that question about working on bank holidays. So
Yes.
that's 1.6 extra weeks a year. If we pay the carers extra to work, so normally double or time and a half, and they choose to work, they choose to accept the money and work on those days, and we still have to give them a day off in lieu. Is that correct?
Right. So I think, are you saying that you'd have I know you'd have an agreement that there's an overtime rate for working bank holidays. So if you work it, you get paid time and a half or double time or something like that. Is that
Yes.
that what you mean? And so then do you have to then replicate that when they take the holiday?
No. What I'm saying is that for the bank holidays, our
Yeah.
carers will choose to work, and the reason they choose to work is because we pay them extra to work.
Yeah.
So if they choose to work on the bank holidays, at the extra rate, I do understand that if they do take off time in lieu, then we would just pay them the normal rate. But
Yeah.
I'm just wondering, so instead of giving 20 days annual holiday a year, because our carers have to work bank holidays, there's no choice really. So if they have the 20 days annual leave, which they can take off as and when they want, and if they do work the bank holidays at the extra rate, at the double rate of pay or whatever it is, does that mean that we have to in 1 year give them off 36 days or whatever it comes to with the bank holidays?
Yes, so 5.6 weeks is for what you might call a normal full-time worker. That's 28 days. It's if you work 5 days a week, 5.6 weeks is 28 days. So that 5.6 weeks actually includes bank holidays. So yeah, quite often it will be expressed in the contract as 20 days plus all statutory bank holidays. But if your staff are getting their 20 days a year to take whenever they want, that's fine. But they're having to work all the bank holidays, they're not actually getting their statutory entitlement there. They need to be given time off in lieu, so they get a total of 28 days. But this is maybe where these new regulations can come into their own a bit more, where it's not really kind of defining a specific number of days. They are just accruing a percentage based on how much they've worked, and that can be taken whenever it's mutually convenient.
Right. Okay. So if in that case there would be no I guess then in that case we could pay the carers on the bank holiday rate. We can just pay them a normal rate. It gets a bit confusing, to be honest, because we're paying them extra so they can work bank holidays. But then if we're giving them off time in lieu, they're actually getting 2.5 times what they would if we're paying time and a half for bank holiday. They'd actually be getting 2.5 times for that one particular day if you add the day off in lieu as well.
Yeah, I see what you mean. That it is going to cost more overall. Yeah.
So that means that every bank holiday we're paying 2.5 times their salary.
Effectively, yeah, because that yes, whenever you're taking a holiday, you need to be paid the same rate as if you as if you had been in work. But you know, if there are certain parts of the work where they're getting paid more, yeah, it is going to be more expensive arrangements effectively.
Can I
Right,
just
okay.
say something with this?
Mhm.
Many years ago, when I used to work in the NHS, if you went a bank holiday, you used to get paid for it, but you would never get a day in lieu. However, if you worked and you didn't get paid time and a half or double, you would get a day in lieu. It was never both of them. So you would never get paid for it and then get a day in lieu. It was one or, either or. I don't know if that is what works in your system as well. So it's never been like you would get paid double because it's part of your work pattern. You know, if I'm rotated to work on Christmas Day, I will get paid double, but I would never get a day in lieu. You know, so the people that were off would get the day off. The people that were getting would get paid time and a half or double. That's how it always used to work.
Excuse, can I also add a point to this as well? Is there a statutory provision that says bank holidays has to be enhanced payment? Is there any statute that says that exactly?
No, that's a bit of a common misconception. That there's nothing. You know, bank holidays are a bit of a kind of artificial construction. As I say, the law just says it's 5.6 weeks or 28 days. Divide that up however you see fit. A kind of easy way to understand it is often that, you know, the 1.6 weeks on the working time regulations is 8 days. There were 8 bank holidays, so that must be what they mean. But there's nothing dictating that bank holidays need to be treated differently to any other holiday, and equally, you know, if it's worked, there's nothing saying, you know, it's a working day. You know, you are just putting people on the road to say this is when you need to work this week or this month. There's nothing inherently in the law to say that they need to be at an enhanced rate. It's just kind of quite common contractual practice to sort of compensate people for, you know, having to work when their friends and family are not working, or if it's more optional, it gives them an incentive to work that. So it's, you know, it helps the business in that way. But no, there's nothing in the law saying that you must pay a certain rate for working on public holidays.
Thank you very much. Because in our contract, we do say we don't pay enhanced payment on bank holidays, and it's true, we can afford it. Thank you.
Yeah,
Well, it sounds like it sounds like you may have just upset a lot of these wonderful workers who were thinking of getting the enhanced bank holidays. So leaving here now, providers. No, thank you very much, Dominic, and thank you for everyone for actually joining on this. I think due to time constraints, there may be some questions that we may send through to you, Dominic. But also as well, I know a lot of the time I get a lot of feedback from the providers now with the international workforce saying how does all of these changes apply to the international workforce, and how does it fit in, which is also another area to navigate as well.
Yeah, that's not a quick one to answer. I think the very quick part of it would be like you'd have to look at, you know, where is their contract most closely connected to, which jurisdiction and which sort of set of laws should most appropriately apply to that worker. But you know, you quite often then have to analyze a lot of things about where do they live, where do they, you know, the people they're interacting or providing the service to live, that kind of thing. So yeah, it's
I think we might have to
complicated.
We might need to call you back in for on that. So thank you very much for that. And everyone, please, if you want, you can actually add questions. The slides are going to be shared as well. And also there's recording of this as well. So don't worry, you're not going to miss out. So thank you very much, Dominic, for that.
Okay. Yeah. Thanks for having me.
No problem. And Peter, I think we've got Mick Feather who's coming in next. Actually, Mick Feather's going to, as an ex-CQC inspector, please don't hate him. He's a very lovely guy, but he works with Citation. The other thing, he's going to try and relate this to CQC and their new framework and how this fits in. So, Mick, I'm not sure if you are available. Peter, if you can switch over, it would be good.
I wasn't aware that I'm doing a presentation.
Well, I mean, I think you're just sharing just
do you want me to just
information.
give you a quick 5 minutes about something?
Please do.
I mean, I'm really Rosie, so I'm really kind of like here to just sort of back up Dominic, because Rosie's having a day off. How dare she? I mean, for me, the only thing that I'd add from just looking at CQC reports over the last sort of 12 months, and we can do this some other time, you know, maybe, but one of the things in terms of HR which keeps coming up, which you'll all say to me, oh, he's talking about it again, which is about Regulation 19, Schedule 3, the usual stuff about employment and evidence and what you need. And it still comes up in reports that I see now. So I'm sort of saying it again in terms of, you know, and let's park overseas kind of like, you know, workers. I'm talking about staff that you have now, or that you may be employing from potentially the UK. Just get those things in order. So, you know, photo ID, you know, their right to work in the UK if that's a necessity. Have you got kind of like full employment history? And there has to be a full employment history. So it's not, you know, last 2 years, last 5 years, last 10 years. It's full employment history, because, you know, it's about CQC looking at those gaps, saying, oh, look, you know, you've got a year gap here. What was going on? So make sure you've got a full employment history. The other thing that comes up is references. So if your own policy says you need 2 references, then you need 2 references. Otherwise, a nasty inspector is going to say, where's your other reference? If you haven't got it, and if you can't get hold of it, so, you know, the person used to work for C&A or Woolworths or whatever, none of you remember that because you're all too young and sexy to remember, but those companies went bust. Fundamentally, if you can't get hold of second references, get a risk assessment, a generic risk assessment, and sign it off to say, I know Dudley. Dudley's been working here for 6 months. He's passed his probation. There's no problem with him. Absolutely great member of staff, blah, blah, blah. Sign it off as the second reference. Don't leave it that you haven't got that second reference. Otherwise, someone will pick that up. If you want to, if you need to know exactly what you need, go into the internet, just type in Regulation 19, Schedule 3. There's a little guide from the CQC which just lists what you need, which will be everything from photo ID to 2 references to what have they been doing for their entire working history. Just make sure you kind of like get that sorted out. And even if it means revisiting existing employees, for you to make sure that you're in this strange world of the single assessment framework, that you've got all that covered. The other thing that I'll just mention, because I'm just aware of time, whatever, and as I said, I wasn't here really to do a presentation, but I would just say in terms of the madness, which is the single assessment framework, stand your ground and be confident about what you're doing. What we need to remember here is nothing really changed in terms of what's actually happening. All that they did was got rid of the Chloes and changed those Chloes to quality statements. The actual fundamentals of what information and evidence and what they'll be looking at and what's needed hasn't really changed. The regulations haven't changed. There's no change in regulation, which basically means if you're bad, they'll try and, you know, take enforcement action. And if you're not, then that's fine. Then we're just worrying about ratings, which we're always kind of like worrying about. But fundamentally, nothing's changed. It's Chloes have gone, quality statements are now here, which are generally speaking just kind of like a rewording of kind of like what the Chloes were anyway. So don't stop the things that you were doing. Keep doing what you were doing. Keep evidencing what you're doing. If it's not written down, it didn't happen. So don't have stuff in your head about, oh yeah, we've got all that. Make sure you have got it somewhere, whether it's on a computer, whether it's on paper or wherever it is. I'll give you an example in terms of my bigger issue that I find, the reason why I'm telling you to be more confident, is about the fact there seems to be, and I'm not sure how true it is, but there seems to be a kind of strange attitude in terms of we've got a new, CQC seems to think we've got a new framework, therefore we can have a new attitude. They still need to be polite. They still need to be asking you what you need to actually provide and what they're looking at. You know, ask them what they're going to be looking at. The issue at the moment is how many quality statements they're actually going to be looking at in an inspection. They keep saying that they're going to definitely look at 11. Well, even if they look at 11 quality statements, that's only 11 out of 34 quality statements. So they're not looking at the whole thing.
Are they actually going to be looking at a whole area? So are they going to look at the whole of SAFE or only a bit of SAFE or whatever? But the thing that worries me is about attitude. The reason why I say that is that I was at an event a couple of months ago in Bedford. And basically, this is the level, the reason why I mentioned about the employment sort of area as well. They basically said, so let's not talk about overseas recruitment. Let's just talk about, recruitment of employees here now or whatever. We all know what staffing agencies or employment agencies are. When you guys are kind of a little bit short, you kind of go to a staffing agency, recruitment agency. If you've got somebody who can come and do a shift or, whatever. The CQC inspector asked them for, where's all the evidence and all the employment evidence for these members of staff that were actually from a staffing agency? So obviously the registered manager said, well, we don't keep those because obviously we've got a staffing recruitment agency that do all those checks and get all that done before they come to us. They insisted that all of that information was made available to them. Insisted, really insisted. Anyway, the person said, well, okay, I'll get hold of it, got hold of the information. It actually ended up in the report. So it was in the report about the factors of not having the information about these individuals that worked for a staffing agency that had done all the checks. It was only when they actually took legal action to have it removed from the report were they able to actually say it's been withdrawn out of the report, we've got rid of it. So I think there's a few things going on. Are the inspectors sometimes knowing what they're doing? Because I would always ask, do it in a nice way, but in a sort of, positively challenging way. If you're asking me for this, where does it say that I need to be doing this? Because in this case, they took it all the way through to legal action in terms of having it taken out of the report, because clearly the inspector didn't understand that if you've got a staffing agency who provide you with agency staff, they should be doing all the checks. And it shouldn't be that you, as the provider, should have all the information about those members of staff. So just be confident about what you're doing and be confident about what you do, because it's really important. And as I said, Peter and Dudley have mentioned already this morning, it's really complex kind of area at the moment in terms of the things they're looking at. But it's all the same stuff. They're not doing anything different than they were. So don't be worried into thinking that you need to be doing something else. Carry on doing really well what you're already doing. The only thing that will be new to us will be sort of at the end of the year when they start thinking about environmental sustainability, which is literally talking about, what you guys can do in terms of your carbon footprint. But, really that's about NHS and big hospitals. That's not about my little dom care down the road where I've got, 10 staff and we do the best we can. We don't we haven't got a bad sort of imprint in terms of sort of carbon, but just be confident about what you do. And I think, fundamentally, that is kind of like where you need to be. The things should still apply. So they should still need to be being polite and telling you what they're actually looking at and what they want. The difficulty at the moment is you've got, I think, absolute chaos. I think the portal's still not working. I would always say give them more than what they're asking for, always. You guys that are good and outstanding, I think Peter mentioned it this morning and Dudley, they've set up apparently like a group that will be looking at good and outstanding services, mainly because probably they're worried that those good and outstanding services that pay their fees still will never be inspected unless you make up a death or unless you make up a safeguarding that's so bad that they need to go in, because they're not going to, they seem to be concentrated on risk, even though they say that that's not what they're sort of looking at. Certainly, when I've looked at sort of recent reports they've done under the new framework, it's all about safety. It's all about safety. So they're looking at kind of like the majority of the quality statements of safety. One that I looked at the other day, they didn't even look at caring or responsive. They only looked at safety and well-led, which is exactly where we were during COVID. They're looking at risk and they're looking at risky services. So think about that. I'm always talking about safety culture. So think about what's the impact of the things we're doing. Write it all down, be confident. I'm going to shut up because you guys haven't got enough time to carry on doing what you're doing. But we can talk about this some other time, I'm sure, when I have got a proper spot rather than me just hanging on the back of the fact that Rosie's not here. But I'll leave you guys to it. I hope that's all right.
Thanks for that, Mick. Listen, I think in relation to obviously inspections, but obviously employment's always good to understand about the references as well. And thanks for sharing that, Mick. I think someone's asked for a template or where to go, so I'm sure he'll tell you about citation in a minute. But
Yeah, just get a generic risk assessment. So the most basic risk assessment, which is, has a title. I mean, I don't know. I've probably got one. I could probably kind of like send one. Just I'll throw it to you, Pete and Dudley. You can send it out.
Just to add a point that Mick made, when your inspectors come in, if you've got a particular speciality, then the inspector coming in needs to have some expertise. And we've had an example where there was a learning disability and autism home, and the inspector basically hadn't got a lot of clue about what was going on in that home, and caused quite a lot of upset to the residents. That is their home, and it wasn't right that was done. The CQC should have sent somebody in that actually knew what they were doing, basically. And I'm not quite sure what the eventual outcome was, but it could have been done a lot better, and it didn't make them any friends. Just quickly, I see there's a hand up from Harriet.
Yes, all I wanted the CQC person to verify is if we can actually use character references as a second reference or third reference.
Yeah, I mean, there's not an issue with that. What you're trying to get is you're trying to get an understanding about what the person's like. If you've got a character reference, which is, and depending on again who that is, because if it's kind of like your best friend, or if it's kind of a family member, that's probably not applicable because they're obviously going to say that you're great. You'd probably need something like an employer, hopefully kind of like your previous employer. But if it was a character reference from a previous employer, that's not an issue.
Brilliant.
Did you get that, Harriet? Is that all right?
I think you scared away, Mick.
Don't know where. Yeah, I've lost her. I think she's on mute. I hope that's all right, Harriet.
Okay.
Thanks, Harriet.
We can pass that on. All right. If there's nothing else in that sense.
Yes, thank you.
Okay.
All right.
Thanks, Harriet. Okay. Thanks again, Mick. Brilliant.
All right.
And
I think we will be getting Mick in at some point, everyone. So don't worry. He's going to do a full session. I think he's going to be put back into a cupboard looking at all the CQC latest sort of inspection results and come back to us. So you hear from Mick at some point. We'll get a date in for him.
All right.
After
Thank you,
he's been on holiday and got his tan. Right. And Mr. Buttle. I thought I saw Mr. Buttle.
Hey, with my little assistant, I'm afraid.
Right. Yeah, we've all got one of those, I'm afraid.
Yeah, I just wanted to see if I could update people on the changes that are coming up soon, I think is the best description to how care training is funded in England. I haven't done any slides because I'm not sure that the slide would last long enough to actually get sent out to people before things change again. So I think effectively what we've got is good news in the medium and long term, in that there's going to be a lot more funding for training going into social care. What we have in the short term is a little bit of a confusing process. Now, what's effectively happening is the Workforce Development Fund that we've been working with for, God, over a decade, is being wound down and replaced by a new direct funding system, which is going to be run by the Department of Health and Social Care directly. It will mean that employers directly are able to claim funding for, at the moment, almost all of the same courses and qualifications that are funded by the WDF, but you won't be able to go through employer partnerships to do it. The employer partnerships effectively are ending on the 31st of May, this end of this month, basically. So, I mean, it's a little bit sad because obviously we've been working with partnerships for a long while, and we're having to wave goodbye to a lot of people who are going on early retirement or getting other jobs. In terms of what happens then, this new fund from the Department of Health should, and well, the problem is they've said that it will be coming on stream in summer. We're hoping it will be as close to the 1st of June as possible, because obviously us as a training provider want to carry on doing funded training in the easiest, simplest way as possible, and to give employers clear messages rather than like today when I'm giving you a slightly unclear message, which I'm aware of. The Workforce Development Fund is carrying on for 1 more year, but again, you will have to apply directly to Skills for Care to claim for that. And they haven't opened applications of how you do that for small organisations yet. Although I'm meeting with Skills for Care National on Thursday, so I hope to find out more then. So what we're looking at is a new Department of Health fund. It's still going to be linked to the ASC, what used to be NMDS account. So you're still going to have to update with all of that same information. They are piloting the claim system for this around the country. Mainly the way that you claim will be very similar. You will need to provide a certificate after somebody has completed training as evidence. You will need to say who the training provider was, and it's looking like they will only accept from endorsed learning providers like ourselves. There is one change, which I know is not going to be popular, which is that they are also going to be asking that employers can prove that they have paid the training provider as well. Believe me, this is not me bringing this in. I quite like the system where we only charge people when the same time the claim goes in. It makes life simpler. And we will still be doing that same process, but you will need to basically, if you've done training with us, for example, we will send you all of the information you'll need to make a claim from Department of Health and an invoice on the same day, but you will probably have to pay that invoice on that day in order to put your claim in to get the money back. We're hoping that this Department of Health system will be quite a fast turnaround. Skills for Care, if you are currently claiming directly from them, is quite a fast turnaround. It's normally a week or less. So that should pretty much run as normal. The only thing significant that isn't being funded under the new Department of Health Fund is a level 2 diploma. They're funding all of the other diplomas, medication training that we do, level 2 dementia awareness, all of the normal stuff, all of the management qualifications that Skills for Care run, like Lead to Succeed, but they're not doing the level 2. So if you have a level 2 learner on a diploma or an apprenticeship at the moment, you have until the 25th of March, sorry, the 30th of March next year to claim that directly from Skills for Care. So there is a backstop for that. The reason at the moment the Department of Health isn't funding the level 2 diploma is because there is a brand new level 2 award in adult social care coming in, hopefully the 1st of June. This is going to be effectively a regulated qualification of the care certificate. I suspect, and I think everyone is expecting too, that if you have new members of staff, you will go on their care certificate training as you normally do. There's nothing to say that normal care certificate training that's non-regulated stops. So the training you do in-house or with us or another learning provider carries on. But this new level 2 award, I think, will be a way for you to accredit members of staff who have started as new, maybe 2 or 3 months ago, done their induction training. You like them, they're putting in the commitment, you want to keep them on. This is a good way of keeping them on board. It will probably be via a workbook, so there will probably need to be with us anyway, 3 or 4 2 or 3 hour Zoom sessions, which we can spread out over 2 or 3 weeks followed by 2 to 3 observations of the learner in work, which we will have to do as the learning provider as well. And that's the big change. And it's much more like if we're doing a level 2 diploma, where again, we have Zoom workshops, the learner completes a workbook, and then we go out and do holistic observations. The interesting thing with this is that this looks like it's going to be funded at around £1,300 to £1,500 per learner, which is way more than the current WDF funding for a level 2 or level 3 diploma. And I think they are hoping that to encourage people to start on this new qualification, withdrawing the funding for the level 2 diploma, at least for a little while, will encourage people to do this. The new ASC will be following all 15 standards of the care certificate, although they are mixing them up a little bit. So they're kind of amalgamating a couple of standards and adding a new standard in its own right, which will be autism and learning disabilities, which is probably a good thing for most people. But it does mean that this will be, it's a new opportunity for us as a learning provider, and we're talking to our regular customers about how we could look at delivering this as well. We are also making sure that all people we've currently got on a level 2 diploma finish before the end of March next year, so that we can know that they can get claimed through this WDF legacy fund, I think is what they're calling it. And I'm also in touch with the Department of Health over when they're going to start funding the level 2 diploma, because whilst this new level 2 care certificate, for want of a better description, sounds great, there is still a lot of stuff that's covered by a diploma at level 2 that isn't covered by the care certificate at a level 2. I probably ought to shut up now because I've probably confused everyone, and I suspect there will be questions, but the headline is WDF is going, there's a legacy fund for 1 more year for people already on a course, and there is a brand new Department of Health fund coming on stream sometime in summer, hopefully the 1st of June. And
Thanks.
I'm just going to give you a link where you can see more information, and that's in the chat box now, about the new fund.
Thanks for that, John.
Yes, bookmark that as well.
Does anyone want to have ask John any questions? I'm not sure, he'll only answer as best as he can. But if there's any other questions you want to ask, there's one question I want to ask you, John, myself. Does that mean potentially there may be a new range of courses available as well, or we're yet to see as well?
At the moment, they have just made sure that they're funding everything, as I've said, except for level 2, that the WDF currently funds. But there is a lot more scope with this new Department of Health fund. So, for example, I would be able to put a course together that is not an RQF level 2 or level 3, just a normal half-day's training on, for example, dementia awareness. I would be able to go to Skills for Care, because they're not disappearing, they're still involved. So I'd be able to go to them and say, this new course matches the priorities for the year. It matches the kind of the core principles and outcomes for this qualification. Would you fund it, please? And they would say, let's have a look. And I show it to them, and hopefully they'd say, yes, we can fund that. And then I can offer that out to customers as a funded course. They are also probably going to be bringing in other courses as and when time moves on. There is also, at the moment, well, over the last few years, there's always been a problem towards the end of a WDF funding year when a partnership runs out of money. And you have to either wait until the new fund opens and put the claim in then, or if you've got multiple branches, you could look at changing to a different partnership. With the new Department of Health fund, which tells you something about how much more money is going into it, they have capped each employer at a maximum of £4 million claims a year, which I suspect is just way up there, but it means that there will be enough money in the fund. which is something we've not had from Skills for Care and the money that they've been getting from Department of Health.
Can you stick your contact details in the chat, please, John?
Yeah, of course.
John does join us on regular occasions, so do share any information you need in regards to training and the updates Peter will be sharing with you with any changes as well, and that takes place. So thank you very much, Peter. We have got about 4 minutes left before people want to run into the sun, so I think potentially can you just update us with a few of the things that we need from people before they go?
Okay, thanks, Dudley. If you're based in the South East London boroughs, then there is a free piece of recruitment support. There's a free hub, free jobs board. I've posted the details in the chat of a short event on the 9th, that's tomorrow, 2 o'clock. If you sign up or contact me, I can give you the details. So it's all free. There's a jobs board. If you're spending money with Indeed, etc. at the moment, you could well save that money and use it on the jobs board that's there. We are talking still with the Home Office about international recruitment, and we're hoping to get them to an event, a virtual event in June. We'll let you know what's happening as we go along. Also, there's a national survey of fee rises for local authority fee rises for 24-25. If you could let me know what they are, please, I'd be very grateful. And I'm aware that some local authorities have yet to announce their fee rises, and that's causing some cash flow problems. If you're struggling to get a reassessment from a local authority, we're interested because there are some procedures here, and I'm aware that local authorities see it. They don't want to do it because they think it's going to cost them more money, but they should be doing it. And it may be a route actually to get a single assessment framework from CQC, because it could be a safeguarding issue, as can withholding money. So let us know about that. And if the local authority says they have no money, if you look at the website or look at Market Sustainability and Improvement Fund grants, there's a whole long list. All the local authorities have been given several £million, and if they're not sharing it with you, you need to ask them. So we've put that on the website, we've circulated it through WhatsApp, but if you want to know any more, let me know and I can point you in the direction. And thank you very much for coming today. Thank you to Citation, to Mick, to Dominic, and also to John and his cat, and to Dudley for chairing the meeting.
Okay.
On the website as soon as we have it ready, and we look forward to talking to you again. And if you have any questions, any topics, then just give us a bell, let us know, and we'll see what we can do to help you out. Many thanks. All the best. Bye for now.